Welcome to NJLaw, the program designed to inform and educate you about the inner workings of our criminal justice system, allowing you to speak directly to New Jersey law enforcement officials who make the decisions in our two-county area. Your host, Detective Sergeant Kevin Quinn of the Township of Ocean Police Department, is an 11-year veteran police officer. He has taught at the Monmouth County Police Academy and has lectured at Monmouth College and Brookdale College.
Hi, I'm Detective Sergeant Kevin Quinn, Township of Ocean Police, and welcome to our February 1st show of NJ Law, your live call-in show. Our number is going to come up on the screen in a second. It's 681-3330, 681-3330, and that's your number where you can call in and ask our panel of experts any questions you have in mind. I also want to take a second to welcome the Ocean Township and Asbury Park viewers who are seeing our NJ Law show for the first time live, which means that you'll be able to pick up your phone and talk right to us and not have a tape delay like you have for the past year and a half or so. My first guest immediately to my left is Adele Keller, who is the case manager for the Family Court Unit in Monmouth County, where all the court cases that involve juveniles come through. Adele, welcome. And next to her is Dr. Martin, or Marty Krupnick, who's the Executive Director of Project Open House, which we'll discuss in a few minutes, which has to do with helping out youngsters who have some kind of family problems and not necessarily of a criminal nature. Next to him is Gary Linington, who is the Superintendent of the Youth Detention Facility in Monmouth County, which is out in Freehold, which is a temporary detention center for juveniles. All of you, once again, welcome. And what we're going to do, folks, is talk about what happens to juveniles when they get in any kind of problem that involves the court system. A lot of you probably realize who have had either damage done to your homes, cars, or for some reason a juvenile committed some type of a offense against you, hopefully not too serious. And you probably wondered what happens once they come in contact with the police and are identified and arrested, and that's what we hope to discuss tonight. Also, many of you people may be wondering if there are any crisis centers available or crisis help in case you're having family problems, and these people can speak exactly to that. First off, we're going to start with Adele, and basically, Adele, Reader's Digest version in 3,000 words or less. Maybe we should take a scenario, which might be a little bit easier to understand, and let's say I, as a police officer, identify Johnny Jones as the actor in a theft, let's say from a store, and for whatever reason, I decide to sign a complaint against him. So I forwarded that out to Freehold. Maybe you could give us an idea of what happens from there.
Sure. Well, I guess I have to preface that a bit. We have a code, a Juvenile Justice Code. It's a fairly new code. It was established in 1984 at the same time that we had a creation of family court. And the code is really quite clear. It tells us that we have to do certain things based on the nature of the offense. And we have a screening process that occurs. So as soon as that complaint comes in, it's signed at the local police department, it comes in and it's filed, it's docketed, and it goes through a very exact process whereby we look at the nature of the offense, we then decide whether it should be diverted from the court process or it should go to court. It then has to go to the prosecutor's office. The prosecutor has to approve the screening that we've done. It then goes up to a judge, and the judge then has to look at the whole matter again. So it's quite exact, and there's really checks and balances so that we as court people look at it, the prosecutor's office sees it, and then the judge looks at it. Based on the nature of the offense and the prior record of the juvenile coming through the system, we would decide whether we should divert the case. And as you know, we have several forms of, we have actually two forms of diversion. We have juvenile conference committees that exist in 40 municipalities or in this county. And it's something we're very proud of because actually the whole concept of juvenile conferences started in this county. And we refer all our first-time offenders to the juvenile conferences. And the idea behind that is that the community should be involved in formulating a reasonable disposition for that child. The community knows what's best, what resources are there, and what would be most beneficial in helping the child. And that's worked very well. We also have something that we call prejudicial conferences, and those are conferences that are conducted by my staff. Those involve cases that are a little bit more complex, but still kids who have committed very minor offenses. And then we have our counsel mandatory calendar, which requires that a juvenile be represented by an attorney, and all serious offenses go in front of the judge on a counsel mandatory calendar.
Now, if a juvenile, let's say, committed a robbery, an armed robbery for lack of a better word, and whether or not he really had a past record, that's the type of thing that might go in front of a formal hearing, as opposed to a minor. Now, the term that we used to use and is still somewhat appropriate, a station house disposition, for lack of a better word, for even less minor offenses where a juvenile comes into contact with the police and, well, let's say it's Halloween. And all towns in Monmouth County seem to have curfews and such. And let's say the child violates the curfew, not by much, but it's a case like that, and the police officer chooses not to sign a formal complaint. Is that provided for in the same act, or is that allowed?
Not at all, no.
Okay.
And that's it's really based on the practices and procedures in each town. Mm-hmm. It's something that the court doesn't really control or say.
Right.
At this stage. One other thing I'd like to say too, with regard to the code, the Juvenile Justice Code, in addition to giving us very exact standards for how we process our juvenile delinquent complaints, also gives us a mandate to establish in each county juvenile family crisis units, and that's something that we're going to be talking about with Dr. Krupnick too.
Yes. Now, if, and we might as well get to that right now because we're going to talk about it soon, let me just jump right over to Gary just for a second. Hi. And talk about, you're the superintendent of the youth detention facility, and that sounds pretty ominous. Maybe you could explain to us, A, what the youth detention facility is, and why do I not want to go there?
I don't know that you don't want to go there at your age, Kevin. However, actually, the Youth Detention Center is established under a statute, and that all counties must provide a safe, secure housing for juveniles who are awaiting court disposition. Obviously, the code, the juvenile code that Adele referred to, is very precise in the reasons why someone would be detained in our facility. And the majority of the reasons are for threat to person or property, and the seriousness of the offense involved. Those are the two main criteria. So that the number of youth that pass through our doors is a very small percentage of the population of teenagers in the county of Monmouth, less than 1%.
And a smaller percentage of probably the total complaints lodged?
Yes, a very small percentage.
Now, if I'm a police officer, and we were talking about this a little before the show, and an adult commits whatever type of offense, I arrest him, and we put it on a warrant complaint instead of a summons complaint. So he's going to be made to post bail. If he can't make that bail, he's detained in the county jail or in a temporary lockup in our particular police station. That's different from what we do with juveniles, correct?
Definitely. You were signing a complaint on a juvenile for a serious matter. The police department enacts the complaint and then contacts the family court and their intake unit and requests permission to detain that juvenile in the county youth detention center. Based on their screening, the juvenile is either detained or not detained. If detained, they come into our facility and have what is called a retention hearing within 24 hours. The retention hearings happen 24 hours, 7 days a week. In other words, they happen Saturdays, Sundays, holidays, and they're handled by some of the family crisis people, Adele's people in the courthouse. There's a judge involved, and the parents are also given notice of where the hearing will be held. and are held, like I said, year-round, no matter what. That's the law specifies that. So it's a bit different than adult in that respect. And then 48 hours, excuse me, after that we have a probable cause hearing in front of a judge with, say yourself, an officer involved who has some interest in the case to give some information to keep the juvenile detained or released.
Now, if I put a juvenile in your facility, obviously your facility isn't in the same place as the Monmouth County Correction Facility or the adult jail, for lack of a better word. And it's separate for a reason. I understand the reason. Maybe you could just elaborate a little bit on it.
Well, the law is very specific, and it's all the way from the federal mandate of the Office of Juvenile Justice, Delinquency, and Prevention. It's very strict on the guidelines of not mixing adult and juvenile offenders. Even in your local municipalities and your local jails, local police departments, it's very strict regulations, as you well know, that we cannot have juveniles even in the same holding area as an adult. And there's some very strict time frames also that you can only detain for a very limited amount of hours before charging or releasing. And it's all for the protection of the individuals involved, specifically juveniles, and trying to keep them within the system and the theory and the philosophy of the family court.
When I bring a child out to your facility and I've gone through all the steps, I've contacted the crisis or the intake worker, and they've reviewed the case and a number of different factors, unique factors, which you specified. I bring them to your facility now. Basically, it's a lockup type facility. It's locked. It has fences and to keep people from getting out as well as getting in, correct?
That is correct.
What is, two-part question. Number one, what is the facility like? You know, is it a warehousey type thing, or do they have separate rooms? And number two, once you have a juvenile there, do you do anything special with them that they might not do with the normal population at the Monmouth County Jail, for instance?
Okay, well, the facility itself is a single-story masonry construction type holding facility. Yes, it is a locked facility. It's different from a jail facility in that there are no bars in a detention center. Today it's mostly uses heavy-duty security glass. There are individual rooms for every resident. Our facility has 39 facility bed space. That's the legal capacity. We also have classrooms, we have laundry room, we have a gymnasium, we have a very large enclosed, fence-enclosed recreation yard, and we have day rooms, and we have, it sounds like there's a lot, but it's a very compact facility, and it's a very small facility in respect to what a county jail might be. You know, our county jail has over 500 beds, and we're only 39 beds, and it's quite a difference. The atmosphere, while hard in the form of being a construction, there's no draperies or carpeting per se. There is a lot of glass and windows, and try to have an open feeling of some openness. But its purpose is to detain and keep those inside that have been ordered by the court detained pending their court hearing. What we do that may be different than the county jail is our intake procedures are very specific and are all outlined, and we have a social worker on duty 7 days a week, different ones obviously, who are available for the purpose of trying to make the experience, especially for the first-time offender, as not a threatening one per se. And they're there for giving information and receiving information so that we can provide for the type of each individual, because everyone is unique, and the juveniles we do serve have a multiplicity of problems, as well as a legal problem. The majority we find have other personal problems, emotional problems, etc. So that we have an in-depth look at the juvenile as in-depth we can with the limited information before they're actually even brought into the population. And it's all to try to make it as comfortable as possible.
If I may, just let me pause for a second because we have a call here, and let me... Good evening, you're on NJLaw. Would you give us your name and your question, please?
Hello?
Hi, you're on NJLaw. Would you give us your name and your question, please?
Yes, my name is Ruben.
Yes.
Yes, if one commits a crime as a juvenile and then he's brought to court as an adult, how is he sentenced?
Good question. Hang on for the answer. Who would like to tackle that one? Adele?
If he commits a crime as a juvenile and then
turns an adult before he turns 18 before he actually gets into the courtroom and answers that complaint.
No, he's charged as a juvenile. He goes through the juvenile process. The only time you would be treated as an adult is if you were waived to or elected to go over to the adult court.
If I'm 17 and 1 month short of 18, and I get charged as a juvenile, and then I go to juvenile court, what part of the question might be is what is the sentencing posture of the court? Can they sentence them to an adult facility, a juvenile facility?
No, absolutely not. Juvenile.
Okay.
At that point.
And does that answer your question, sir?
Yes, I have one more.
Sure.
What do you think of capital punishment for very serious crimes for juveniles?
Personally, I can't comment on that, and I know that our court personnel,
thank you.
the people who are on the panel here, at least two of them, are employees of the court system, and as such, we can't comment on sentencing posture, so to speak, by the court. Any other question we can take, though?
No, but thank you for your time.
Thank you. Oh, that's that. Now, see, that's what we're talking about, but it worked out just fine. What I'd like to do now is jump over to Dr. Krupnick, and in prefacing the question I'm going to ask him, which I promise won't be lengthy, involved, or confusing, I promise. We've talked a little bit about handling juveniles within the court system after they've had complaints. We spoke to Adele about screening and things, and we talked to Gary about, well, if we have to detain him, this. Maybe we should talk a little bit about juveniles who kind of have dealings with the court system, or even the family court or the crisis intervention, or the police. Perfect example is runaways. We deal with runaways all the time, obviously because the parents report them missing, and we get involved. So first of all, obviously, hopefully the people know that we don't arrest runaways. And we obviously don't put them in a detention facility for running away from home, because that's in itself is not a crime. My question is, what did we used to do, and what are we doing now?
Well, I can tell you what we're doing now, and maybe Adele or Gary can speak to what we used to do. Project Open House was established in November of 1986, so we're in operation a little over 3 years right now. And when they'll explain the prior program, our program is we house the juveniles with families. We have 6 families. We have a capacity of 12 beds. The juvenile in the family crisis has to go through a family court screening. The family court crisis intervention unit is called in on the case. They do a case conference with the family. They discuss the options that would be available to the family. And if there are no other options available, then the family crisis unit makes a referral over to Project Open House, at which point our staff would then take over and do an intake into our program. We would house the juvenile with one of our 6 families. The average stay is about 5 weeks. During that course of time, they have a complete psychological evaluation, social work evaluation. We have a pediatrician who does a full medical within 24 hours. We have a drug and alcohol screening. Try to get at all the root causes, if we can, of what led to the crisis in the first place. Throughout the entire process, the juvenile is always under the jurisdiction of the family court. There are regular sessions that are scheduled in the courtroom. We have to bring the juvenile back for a hearing before the judge. Basically, the judge certifies that they can stay in the program, certifies first that they can go in the program. I'm not sure if certifies the right term, but allows them to go into the program, and then continues their stay in the program. At the end of their stay, our staff has a package that we put together for both the family and the court, which determines a long-term plan, looking at the resources that may be necessary, looking at perhaps another place to go beyond our program. But essentially, we look to have as many resources available for the juvenile and the family to remove the problem or to assist with the problem.
Now, it seems to be a whole lot of programs available for youths and their families, especially here in Monmouth County. I know Project Open House, and we'll talk about what happened, or what used to happen, is somewhat unique to Monmouth County throughout the state, and is a pilot program that I know we're very proud of. Maybe Adele, could you touch base on the
I think it's unfair
shelter?
to ask Marty to give himself pats on the back, so we'll have to give him some pats on the back. It really is a very unique program, and since we've had this program in this county, it's been very successful. There have been some wonderful things done for kids and for families. And it's not to say that what used to happen wasn't all right too. This is just a better way to do it. And I think that we've learned a lot about dealing with juveniles and families in crisis over the years. Years ago, many years ago, I hate to tell you how many years ago, when I first started, we used to put kids who were truant and incorrigible and ran away from home in jail. That used to happen. The law allowed that to happen. There's been a real rethinking and reshifting all over the country, not just in the state, that family problems, the answer to family problems isn't, putting someone in jail. We've had a big change since the new Juvenile Justice Code in 1984. At that point, with the new code, the law says very clearly that we can't even sign a complaint against children who run away from home or who are incorrigible or who are truant. And before that, we used to be able to do that. And I think it's worked out very, very well. The new code tells us that we must treat the whole issue with a lot of sensitivity, and we must try to encourage, once again, community involvement, resources, and it states right in the code that before someone enters Project Open House, that we have to exhaust all of the resources in the community. We have to absolutely prove beyond a doubt that we have made every attempt to keep that child and that family together before we separate that family. So, I mean, that's a really major change that has occurred in our law. Once again, getting back to Project Open House, I think that the difference is that we used to put our juveniles who were having family problems in one place. We used to house them in something that we called a shelter. And it really was an institution. I mean, there's no getting around that. And now that we have a home-like setting, I think it's made a world of difference. And I think we've all been really very happy with the results that we've seen.
Gary, you remember the old gin shelter?
Kevin, I remember it well. In fact, so well that I used to work at the one in Asbury Park back in the mid-'70s. Originally, the shelter concept in Monmouth County was split up into two areas. We had, it was division of the sexes. We had females housed up in Wickatunk at the Colliers facility, and we had boys originally housed down in Asbury Park at the Monmouth Boys Club on Monroe Avenue. And that went on for quite a few years, and then I think through whatever means, there was a joint shelter put together out in Walt Township with both male and females, and that started to cause more problems than we had previously. And we found over the years that putting troubled juveniles, runaways, incorrigibles together, some are more intended to run than others, and we had a history of some running together. One runner would take a non-runner, and we'd have quite a few problems. And as Walt Township Police and Asbury Park and Marlborough Police remember, we used to have quite a few problems with runaways from those type facilities, and it took a lot of manpower, a lot of hours out of the police work trying to hunt down the kids.
And then the only answer to that was put a fence up around a place, and then that's the detention concept, and we don't want to do that.
Exactly.
Let me just take this call, and we'll continue. Good evening. You're on NJLaw. Would you give us your name and your question, please?
Yes, my name is John. I'm calling from Bradley Beach.
Yes, sir.
My question is, in December, my car was broken into by several youths, and I'm due to go to court later this month. I was wondering if somebody on the panel can explain to me what I might be encountering when I get there, because I have no idea.
That's a pretty good question, because I guess a lot of people are confused by the court system as a whole, and the juvenile court system or the family court system is a little bit different from that. So, Adele, maybe you could explain how
I would like to, and I'm not trying to cut you off, but you probably, this question should really be posed to the prosecutors, the prosecutor's office as well. We certainly hope that your experience will be, I don't want to say pleasant, but we certainly hope that you're coming into the courthouse and going into court will all be done in a very timely fashion. However, you will probably, as a victim, will be speaking to the prosecutor, and for the most part, will be getting a better sense of the case from the prosecutor.
If I can, sir, let me ask you this: are you going to a trial?
I just got a subpoena. It says that I have to appear before a judge as a witness.
Okay.
It was my car.
As a witness in any criminal case, obviously you go into court, you're sworn, and you give certain testimony as to what happened. If you're the victim and you didn't actually witness the offense take place, basically you'll be testifying to the fact that, yes, I was the victim and this is what I am missing or is damaged. The juvenile or the family court, in that respect, as far as testifying or testimony, isn't really too much different from any other court. That's why I asked you if you were going before a judge, because if you're going to a conference, something different might happen. But if you have any questions as to what to expect when you get there, you can either contact the prosecutor's office, and there should be a number on your subpoena. If not, you can call the main number, and another place that's probably, hopefully either a joining letter or somewhere around there, you might have see a number for the Victim Witness Assistance program out in Freehold. It's part of the prosecutor's office, and they offer assistance to victims and witnesses and kind of explain and walk you through a little bit what to expect at a trial, and tell you what your different options are.
One other thing, too, I just want to say, if you have any question concerning the date of your hearing or the location of the hearing, please contact my office, and the number will appear on the screen where it says to volunteer for court volunteers.
Yeah, that number's 431-7887, and we're going to put that number up again later on in the show, so if you'd stay tuned, because I know you're riveted to the TV because it's so interesting, that you'll see it come up on the screen again, and then maybe you can jot it down if you have any questions. Okay?
Okay, thank you very much.
Thank you for your call. We're smoking the lines here. Good evening, you're on NJLaw. Would you give us your name and your question, please?
David from Long Branch.
Yes.
Yes, don't you feel that sometimes we find laws that are supposed to protect juveniles are exploited by adults, like in such cases as drug dealers use 8-year-olds to sell their cocaine and other instances?
Yes, and you mean thinking that less will happen to the juvenile, therefore they can use them to...
Exactly.
Yeah, Gary's nodding his head too. There are specific statutes contained in our Comprehensive Drug Reform Act, which went into effect a couple of years ago, that address those very problems. And basically, they give or they provide for very harsh and plea bargainable sentences for people who use in drug distribution schemes. So people who used to think that that was a cute way of getting around something are finding out that that's not necessarily the fact anymore. I don't know, Gary, you want to comment further?
Well, we have had situations where we've had juveniles in custody on such charges who've had either family members or other people who have utilized their services for the selling of drugs. And what the court does is they try to work out in the best interest of the juvenile what they feel will be their outcome, and they usually wait till the adult case is finished before they even deal with the juvenile case, because they want to give the juvenile every opportunity to make arrangements. So while, yes, the laws are there to punish those that utilize the juveniles, the court is very understanding in the family court's philosophy, realizes when someone's been manipulated or used, and they try to take that into consideration at disposition.